and welcome to Collaborative Divorce Vancouver's first Q&A series to inform and educate professionals and the public about this alternative legal process that families can choose when getting divorced. Collaborative Divorce Vancouver is a group of financial, legal, and mental health professionals that dedicate their practices to helping families get divorced using an alternative process to litigation called collaboration. I am your moderator today. My name is Jenny Weeks, and I'm a financial specialist and board member within the Collaborative Divorce Vancouver group. Please feel free to put your questions in the chat, raise a hand, and I will unmute your microphone. There's total confidentiality coming to this group, and your name will not be released. I have curated questions to start, and I'm looking forward to audience participation. This is being recorded and will be available for viewing on our website. Today, we have one of our founding members and most experienced family law lawyers, Gordon Kopelow. He's going to answer some questions about collaborative divorce. He has his own firm in Vancouver and has been practicing collaborative law for over 20 years. He's also an active member of our practice group and has been an instructor within the Law Courts Education Society. We are very fortunate to have him here today. So welcome, Gordon, and thank you very much for joining us. And tell us, Gordon, what is collaborative divorce?
Well, the basic gist of collaborative divorce is that it's a method of resolving family disputes without going to court. You sign a participation agreement at the outset saying that you are going to work with the other collaborative lawyer and your partner or your spouse and try to resolve this. If you are unable to resolve it, then the lawyers back out of the process and the people can go to use other processes. And there's obviously a number of ways of resolving family disputes. I like to say, I mean, if you look at it as a spectrum, on one end of the spectrum is the two people sit down at their kitchen table and they write out what they think they should do and maybe put it on a piece of paper and sign it. At the other end of the spectrum would be two people who don't speak to each other, hire lawyers, go to court and ask a third party, that is a judge, to make a decision about all of the matters involving their family. In between those two extremes, there's a number of ways. They used to be called alternate dispute resolution methods, but I don't think that's a fair name anymore because it's not really alternative. Most people don't go to court. Only a very, very small percentage of people go to court. So there are ways of resolving the dispute. But most people can't resolve everything at the kitchen table or shouldn't. So, I mean, if you're young and you have no assets and no children, then maybe you could sit at the table and say, you get the cat, I get the dog, and you can have the table, and that's it. And then you could write that, and there really wouldn't be any economic consequences. But for most people, you're going to have enough assets or enough issues that you're going to at least have to run it past a lawyer to see if it's legally binding and if you're missing something. So along the way between the kitchen table and courthouse, there's mediation, collaboration, arbitration, and then litigation, which is what we call going to court. All of these are methods that could work to resolve a dispute. Mediation involves the parties going before a mediator, and the mediator it doesn't necessarily impose his or her views, helps the parties come to an agreement. If they write up an agreement, usually called a separation agreement, they write that up, then they send the people to individual lawyers to get independent legal advice to make sure it's a binding agreement. You really, in order for an agreement to be binding, there needs to be somebody, both parties need to have had legal advice. There was an article in the paper not too long ago about now this one lawyer model of resolving family disputes. It's really contrary to everything in our legal system, which is that everybody needs the ability to have independent legal advice. So the benefit of mediation is you don't necessarily need lawyers for the mediation component. You only need them afterwards. But what sometimes happens, you go to the mediator, you get an agreement, then you go to the lawyer for independent legal advice, and the lawyer says, I don't like this agreement at all. And the whole thing unravels. But generally, mediation is a great way to resolve things if it can be done. Collaboration involves both parties having a lawyer, going to a room, not unlike mediation, and collaborative lawyers are trained in mediation, and resolving their dispute with the two lawyers in the room. Then one of those lawyers writes up the agreement, and so you don't need to go away to a different lawyer to have independent legal advice. So that's what I like about it. It's like a process that you're there when the agreement is being formed. You understand it because each part of the process you're being advised by the lawyer, and then at the end, the lawyer can sign off and give you the independent legal advice. And arbitration, just as another example, is perhaps there's one issue that you can't resolve. You can go to an arbitrator and say, we've resolved everything. We've resolved all the parenting issues. We've resolved some of the money issues, but we can't resolve what to do about this, say a pension, say. So you give your discussion, you discuss that in front of the arbitrator, and the arbitrator makes a decision on that one point. So all these different ways of resolving things, and they all have benefits to them, and they can all work together. There's no reason why people who believe in collaborative law or which should be against mediation or arbitration. Uh, Litigation, although in my view brings out the worst in people, and it brings out, it raises the level of conflict. And there's always there's always something to disagree about, and that exacerbates the conflict, I feel, the litigation model. So I like to say that I do collaborative law, and I try to keep it as close to the kitchen table resolution as possible.
Yeah, thank you. That was well explained. What might be an example of a different outcome that a family who divorces collaboratively might experience?
Well, I mean, there's room for all of these different methods in resolving disputes. But what I like to think, the lawyers who are trained in the collaborative process have mediation training and are also looking to resolve things without going to court. A litigation lawyer is trained in making arguments that will convince a third party, a judge, that their party is right. That involves marshaling the arguments and making the best possible argument, which can also result in knocking down the other side. It's very adversarial. It's a zero-sum game. We win, you lose. Collaborative just doesn't work that way. So you have people, and I not just myself. I think almost everybody I work with in the collaborative group wants to succeed. They want to succeed for the benefit of both parties. They see the family as a cohesive unit that will benefit from the less adversarial approach as possible. So sometimes you can say, for example, I get people all the time who come into my office and say, my partner is narcissistic. My partner is very difficult. My partner has a drug problem. My partner, all these things. And my job is to say, okay, so this is the person that you raise children with, and this is the person you're going to continue to raise children with. How can you work together to make this better? Whereas in a litigation model, they'll be like, oh, okay, if he's got drug issues, tell me all about them, because we're going to make this, we're going to put this before the court in a way that the court will be less sympathetic to their side and more sympathetic to our side. So the outcome is obviously, you're in some ways trying to create a dispute or make the dispute bigger. If I say that if someone hears from their spouse that, say, they've got issues with their parenting, well, generally what they're going to do is come back with, well, you've got issues with my parenting. Well, I've got issues with your parenting. And it escalates. Whereas in a collaborative group, we'll say, well, what are the issues? How do we deal with those? And we also, which is fundamental to the collaborative process, we work with mental health professionals and financial people so that if there's an issue, say, for example, one of the partners says, I don't really understand finances. You've always run these finances, and I don't understand what you're doing, and I don't trust you. We can say, okay, that's a legitimate response. We're going to send you to somebody who's going to be able to explain the finances in such a way. And that independent person could say, yes, you've got reason not to trust your partner because they're doing all sorts of things which are very strange. And I haven't seen this before, or I don't believe that what he or she is doing is correct. Or they might say, you have no reason not to trust them. These are typical things. These are things that people do. And here's why, and explain it to them. and they will believe a party who's not party to the dispute, who's somebody who can say, look, I'm just trying to help you here, and I don't have a side in this. I'm just trying to help your family. So in that way, you can avoid some of the problems that other processes get into.
Hmm. So are there any risks to choosing this process?
Well, I'd have to say that there are people who come into collaborative law hoping that there'll be less financial disclosure, because in the litigation model, you have something called an examination for discovery, where somebody can be examined for 3 hours, sometimes longer, on all of their financial matters. And some people say, oh, I'll go to collaborative because they don't do that. They just, sit around a table and have these discussions, and maybe I can get away with something.
Hmm.
Which is why it's pretty fundamental to all of us in our collaborative group that we are on top of all of these financial matters. We work with independent people as well to have complete financial disclosure. And because our collaborative group, basically there's 20 to 40 lawyers, but probably, most lawyers work with most of the lawyers in the group. We have a collegial bond, so that if we think that somebody is coming into our process to exploit it in some way and not give full financial disclosure, we shut that down pretty fast. And I really think that collaborative professionals help get all of the financial information out. And I haven't seen a situation where somebody comes. I mean, I've seen people come in and think, oh, this is going to be easier, I'm not going to have to disclose as much financially, and then they're usually disappointed because they actually have to disclose quite a lot in a lot of different ways, and they're asked a lot of different questions by a lot of different people. So I think that
So it's not a risk then, really.
I don't think so. I mean,
Yeah.
I suppose so. I don't think there's a financial risk. I don't think there's a process risk. I suppose the risk is the process involves more trust. You have to not necessarily sit in the same room, because we have the typical four-way process before the pandemic was four people sitting in a room having a discussion. With the pandemic, we had a lot of Zoom meetings and the ability um, to not be in the same room together. But generally, I like to be in the same room. I find it's easier to communicate in a lot of ways, but it's a little difficult. You've had a serious relationship with somebody that's coming to an end. You often don't feel like you want to be in that room and exposed to these conversations. That room has to be a safe place. So the onus is on the lawyers to make sure that it's a safe place, but it still is a risk. You're walking in, and a lot of my clients, they're not very happy. They don't really want to go into that room. So I would say the risk is mostly emotional. You're taking a chance. You're going to be in that room. It's possible that your spouse is going to say things that are going to upset you, and you're relying on the lawyers there to keep it a safe space, so that you're not going to be if, for example, the relationship was abusive, and I don't mean necessarily like violent, uh, that may or may not be the best case for collaborative, but emotionally abusive. One party was either demeaning or treated the other party in a way that made the other person feel bad. Um, our job is to make sure that that doesn't happen again in the meeting. So it has to be a safe room. So there is a risk, and so, people sometimes say, I don't know that I really want to go into that room with him or her. And we say, well, could you at least give it a chance once? Let's see if we can protect you and provide that safe room to have that discussion. We can take timeouts. We can do all sorts of things to make sure you're protected. But I would say that's the biggest risk, is that people are being more vulnerable. The whole process is more open, it's more transparent, and you are more vulnerable, as are the lawyers. Because when you go into court, you're not trying to be a nice guy. Like you just go into court, you put on your robes, and you make your argument. You don't really have this discussion. It's all sort of it's not personal, But when you're in a room and someone's upset or crying and doing all this, you've got to have your tissues there, and you've got to have your empathy with you. Otherwise, you're not doing the job that is required in collaborative.
I would say that from my experience, one of the concerns anyone getting separated has is that they're not going to get their fair share.
Yeah.
So can you address or talk about how you address that within the collaborative process?
Sure. Almost every client comes in and says, I just want my fair share, or I want it to be fair. Okay, but fair is not a objective term. So the advantage of a lawyer is you can say, well, um, there are laws that set out, for example, in BC, things are split 50-50, except for with some exceptions. So you can go through what the law says is fair, the law, at least in BC. And so that helps people. But what the collaborative process tries to do is we start with what we call a hopes and fears session right at the outset, where we ask people what they're worried about and what they hope for. And we try to make it over the longer term. So not what we hope for today, but where you'd like to be 10 years from now or 15 years down the road. That way, people in conflict or people in turmoil often get caught up with the tree right in front of them as opposed to the forest. And so they need to be thinking a little bit farther down the line. So they tell us at the beginning what their concerns are and how they want to be, and that helps us, move it along in a way. Sorry, I'm lost the thread of your question though. So let me.
Well, just about dealing with fairness, like to me,
Yeah.
one of the risks would be that that you don't have, like, this, as much as there's a risk of going to court, I think people feel like when the law is seeing it over, that's what their fair share is going to be, what the judge says, as an example. And I think it's important to understand that that's just not true, first of all. Oh, I think I can't hear you. Gordon, speak. No, we've lost your feed. Mhm. Can somebody raise their? Okay, so just talking about risk in choosing a process, you've mentioned that you don't see a risk of being financial. My suggestion is that sometimes people think by going to court that they are going to get the resolution that they are meant to get, and that there is a perceived risk in going through collaborative, that there might be something left on the table. So we were just talking a little bit about, maybe you can address in terms of what it looks like going to court, because you used to do that, right?
Yeah.
Versus outcomes that you see for families, monetary and otherwise, and perhaps the risks of not choosing a more conflict adverse process.
Well, I mean, I suppose, first of all, I think the first thing we should discuss is that the actual cost of going to court used to be exorbitant and is now beyond that. Like 95% of my clients cannot afford to go to court. So that option really is not on the table. The expenses for even a short family trial are in the hundreds of thousands of dollars. So
Jeez.
most people just simply can't afford that. And so that should be said. The other thing is that, this idea that a third party is going to be able to make a decision, and that decision is going to be more fair than a process with a mediator or a collaborative lawyer. Again, the Supreme Court judges, some of them have family experience, but a lot of them don't. So you may be finding a lawyer who's only practiced criminal or civil litigation and never done family matters, and now having to decide a family issue. Here, we've got lawyers who specialize, they only do family law, and they know the laws, and they are able to assist, and it's much, much more financially viable than the court process. So I know people going through this are insecure, they're anxious, there's all sorts of concerns, but hopefully their collaborative lawyer can show them, can deal with those concerns. And I'm often asked about sort of marketing collaborative family law, and I don't see it that way. I actually believe I've done litigation, I've done all sorts of litigation, family matters, and I absolutely believe that this process is better for people, almost everybody, all the time. So it doesn't require a lot of to me, I think when people come see me, they can see that I actually believe what I'm saying, and so it's not like a marketing trick or anything. It's just this is the real thing. It really does work. It really is better for people.
Hmm. Well, my
So,
next question was why you chose to work only within the collaborative process, and you sort of answered that. But is there anything else you want to add?
well, I mean, from a lawyer's point of view, and I don't know, there were some lawyers who were listening to this. Uh, it's I mean, it brings out different parts of your personality. So, I've been a lawyer for over 40 years. So when I started, I was a pretty young guy, and I enjoyed the litigation process. You go to court, you sort of fight the good fight, and it worked with my personality at the time. As you get older, you sort of wonder if you're actually adding to what the benefits are and how you're helping your clients, and you value that. You want to provide value to your clients, and to me, it's really a no-brainer. Working collaboratively is so much more productive for the clients and so much more rewarding for the lawyer. So not a problem. There was a period. What was difficult was the period of time when I was doing both, because I was worried there wouldn't be enough work. So we were just starting this process up, and so I would do some litigation and some collaborative. That I found was very difficult, and I think it's a very difficult way to be in the world, because if you're doing litigation in the morning and doing collaboration in the afternoon, there really are quite different approaches and require different personalities and mindsets. And I think that it's much better to be just doing one or the other.
Are there any families or clients who just wouldn't be right for this process?
Well, probably, but very, very few. I mean, I start from the presumption that everybody could benefit from this. If someone is threatening, won't listen to their lawyer, and is if the party just doesn't feel safe in the room because this person is really not able to see the benefits of open and intimate communication, and there are people like that, then the process isn't going to work. You can, but it might. So, and I think there's very few cases. Like, for example, I have done cases where there has been family violence, and um, we've reached a settlement, and it's been a better settlement than it would have been in another process. I've done some very, very difficult cases. There's some very talented collaborative lawyers that I've worked with, done cases involving sharing parenting with one parent living in Australia. Things that you would think, well, that's not going to work. But somehow, the parties discuss and they talk about what'll work for them and what wouldn't work for them, and they come up with something. Um, Usually, like a mediator, there's usually somebody wants $10 and the other person wants to pay 5. You come up with 7.5, and there you go. But for example, with this Australia, it wasn't what you were going to be able to do week on, week off with somebody living in Australia. You're going to have to be a little bit more flexible. But in some ways, that brings out the best in the process, because the people say, okay, we don't want to have all or nothing. So we want to find some sort of compromise. So they come up with things that could work. So I would say that almost everybody could benefit from it, and not everyone is going to succeed. Not all our cases succeed. I don't know. My success ratio is in the 90 something percentage, but there's still people who aren't able to do it for whatever reason. My favorite or my easiest clients to deal with, though, are people who come from litigation first. They've litigated for a while, and then they realize that that doesn't get them where they want to go, and they're quite happy to be in the collaborative process.
Yeah, I think from my experience and what I've seen is that as you enter into a legal process and you're entering into a separation, what a couple really needs to realize is that they've chosen a divorce and they're going to have to come to a settlement. And there's no win, and you've got two parties in conflict that have to find a settlement. And so finding an approach that can provide the best outcome for your family is really the ideal. And I also work within as a financial within the collaborative process. So I do believe that it is a great option for families. And I also believe that there's an opportunity to create a different and unique family unit after divorce. And this process provides that. And the more conflict you have in your separation, the worse your relationship is after the fact. And you are still a parent. And, so I would say that this probably serves families with children the very, very best, because there's two little people or three or five or one, there's children. Right. Sorry, yeah. I have two. There's children who are, who have to remain in that relationship with two parents, even though they're not married anymore. So I'm cognizant of time. We're trying to keep these Q&A short. I'm going to ask everybody that comes to this, every professional, what advice would you give your best friend or sister, someone like that, if they were separating?
Well, I mean, I can say I have been talking this talk for 20 odd years. When it came to my personal life and when I had to go through a separation, I chose the collaborative process. I chose lawyers, one lawyer, and we went through it. And I can say it wasn't fun. It wasn't the best, the most fun I've ever had, but it was a safe room. I thought that it was resolved in a respectful way, and my ex-partner and I think, benefited greatly from the process. So that's what I would say. Anybody that I cared about, and I care about my clients as well. I really do want people to have the benefit of this process. It's like somebody comes in, and you can either speak to we all have better angels and worse, and you come in and you can speak to that person to the best part of their personality, which is difficult to do when you're in the middle of a divorce, or you can speak to the worst part of their personality. And I think collaborative speaks to the best part of them. We try to say, look, I know you're upset. We have coaches, divorce coaches. Who can work with you and have this. You can have this discussion and deal with that. I know you're not trusting. We have financial people that you can go to and satisfy yourself about that. I know you're worried about what the law is going to provide for you, and we can sit down and have that discussion. And me and the other lawyer, even if we don't agree on everything, we can model the behavior of, should spousal support be 5 years? Should it be 10 years? Should it be, why should it be? What are the responsibilities of each of the parties? We can go through those discussions, and we can do it in a way that's going to allow you to have an ongoing relationship with your ex-spouse. Now, I don't want to be lollipops and rainbows. A lot of people in our process, at the end of it, they settle it, and they don't all go for Sunday dinners, but some do. And it allows for people to achieve the best possible settlement and the best possible accessing the best part of their personality. That's all I can say. And the lawyers too. I think it brings out the best in lawyers, and as well as the clients. So I love the process.
That's well said. Thank you very much, Gordon. I'm going to open this up now for questions. I have through the meeting chat group. I haven't seen any. It is a Q&A. Confidentiality, feel free to put it in the chat. I won't mention names, but if there are any questions that are prying on your mind, please do please do put it in there. You've got a lawyer in front of you here who has a lot of experience and would be happy to answer your question.
Or maybe I've explained it all so well that there's nothing to be asked.
So I haven't seen anything come in. I'm just going to make a just sort of a follow-up. So this recording will be available on our website. Collaborative Divorce Vancouver is our practice group. And please feel free to share it with anyone that you know that is starting to go through separation and has, wants to find out more. I know from talking to people as they enter separation, the fear and the anxiety is very, very high. People have never gone through a legal process in their life, and now they're not just getting separated or divorced, but also having to navigate that. And so that is part of also what we're there for at Collaborative Divorce Vancouver, is to help you navigate your way through that legal process. And I don't see any questions. It looks like everybody's headed out. So again, I want to thank you very, very much, Gordon, for your time today. And, this could make you famous.
I'm not sure that's something I want. But thank you.